This is our quick agenda of what we're going to be talking about. Some of the topics we're going to be speaking about are work scope of works in your contracts and change order disputes, force majeure provisions, who owns the work product, insurance requirements, and liability limitations. These are topics that everyone in the construction industry deal with on a regular basis, and I think from taking the key points of this conference going forward, you'll be able to tighten up all of your risk and tighten up your contracts to avoid costly disputes later down the line.
Okay, we'll start with the first one if that's all right. All right, so this is managing risk with respect to defining the scope of work. It sounds like such a simple idea, but you would be surprised at how terrible sometimes contracts can actually state what the scope of work is. This is critical to define what the scope is, whether you're an architect, a contractor, whoever you are in the mix, because everybody should understand what the expectations are of what's being delivered. When there's a proposal or bid submitted, you should really look to see what the exclusions are, what's not covered, what's not included. You should look at the legal terms and conditions that are typically attached to those proposals, which a lot of people don't look at. These all can define what you are receiving or not in a project. From an owner's perspective, it's very important to understand what's included in the base work versus what might be considered additional work or change order work. And that is often where there are disputes between the parties. So very important to define scope of work. In terms of cost estimating and redesign to budget, this is also a topic that is often struggled with on projects. At the onset of an architectural agreement, the owner and architect should define who's determining what the cost of the work is. Most of the time, people don't want to rely on architects. I represent a lot of architects, love them, but this is not what they do. You should really have a third-party cost estimator estimating the cost of the work. And when are those cost estimates going to happen? Usually you have it during the design phases, but it's important to set the dates so that the owner who has an expectation that their project program is going to happen within the budget and within the schedule is actually met. And I think that a lot of times there are friction points or risk issues that evolve when the parties are not aligned in that. Oftentimes there'll be a request for redesign or value engineering reviews that lead to redesign, and for an architect it's important that perhaps this doesn't happen in the construction documents phase when they're detailing the final details. If there's going to be changes in scope, it's a little easier to adapt in the earlier design phases. So in terms of setting this, we're talking about risk today, but it's a risk in terms of the pricing and who's paying for the additional cost if this is not defined. I think we can transition into the decision maker role. This was a good segue for that when there are disputes about the costs.
So I want to just, I don't know, there you go, hold it down, I guess. So I think for what I'm seeing for contractors, the key on your scope of work is to make sure your work is always, the scope of work definition in your contract is tied to your specifications. And a lot of times there are just kind of terms in there will provide first class workmanship, because I mean it's such a generic term that no one really knows what that means, and if you get into a dispute, you're going to fight over what first class workmanship means. I've seen contracts where someone's only supposed to do the plumbing on the first 3 floors, and the contract will say make sure they'll perform all work necessary to obtain a certificate of substantial completion. And that would include work way outside of the agreed-upon scope. And then, as Will said, that ambiguity and kind of confusion leads to change order disputes, because the courts will look at your scope of work provision to determine if something's additional work or if it's contract work. And if your scope of work is vague and ambiguous, the court's going to likely find that it encompasses the work that you believe is additional. So this is why I think we could talk about initial decision makers. I think Melissa and I have different ideas on this. Melissa is much more in the design space and represents a lot more architects and engineers, and I work more closely with contractors and subcontractors and owners. So for my parties, I like to recommend that they include in their contracts the initial decision maker. Now, the initial decision maker is generally the architect, and that it kind of creates a semi-formal, non-binding dispute resolution process where the contractor who believes something is outside of their scope of work presents their position to the architect, who then looks at the plans and decides, not in a non-binding fashion, whether the work is contract work or if it's additional work. Now, the architect doesn't generally get compensated for this outside of what their initial contract is, and I mean, she can obviously say that. Yeah, exactly. It really depends on it, but I like to say that what it does, it allows the parties to get a third-party view on how a court might interpret this the work, and it kind of gives you a heads up and how to negotiate and how to try and resolve an issue without stopping the project and having a full, performing work under protest and then having to fight at the end of the project over change order work, which could be millions of dollars at the end of the day. So I like to try and get the initial decision maker as part of the contract because it allows people to get a kind of a non-binding, a third-party, impartial view. I mean, then there are questions as to who pays the architect as the owner. So is the architect more likely to side with the owner? Who knows? But it's nice to get that in paper, get that decided early on, and it's a way to hopefully avoid long, drawn-out, nasty disputes.
I could just add.
Of course.
That's fighting right there. That would mean to say.
No, I would just add, as a design professionals typically don't like to play that role unless it's an additional service because it is a lot of extra work. But I sometimes tailor the contracts to say they'll make initial recommendations. This way, it's not a long, drawn-out process, and it does contemplate the parties meeting, conferring, and trying to resolve. And then, if that doesn't work, they can do their dispute resolution. But the goal is claim avoidance, right?
Exactly, but the goal is claim avoidance. If the initial decision maker is going to come and give a recommendation, hopefully the parties take that to heart and see how a court would likely rule, and then change their position and try and come with a negotiated settlement, avoiding a claim, keeping the project on track, keeping the deliverables all on track, and not messing up with deadlines or causing unnecessary delays, which can come back and hurt the contractor and subcontractor if they're delayed off a performance milestone. Next slide, please.
Let's go to the next risk.
Here we go.
All right, so this is who owns the work product, and you ask, why is this on here? What is the risk? So here, the risk is this. It depends on who owns the work product and what you'll be able to do with it. As an owner, you typically want to own the work product so that you can use it to build your project in the future, to add to it, to modify to it, or to replicate it somewhere else in its entirety. An architect doesn't want to give up ownership of their work product. They'll often suggest what the AIA documents provide for, which is giving a license to use. It's an exclusive license, it's a license that's conditioned on payment and a release or an indemnity in the event of misuse. So really, it's important as an owner in a project to understand what your rights are and what you're able to do with the drawings. And the risk comes in where the relationship sours with the design professional, and let's say the owner decides to terminate. Can the owner then take the work product that they paid for to date and use it with a new professional to finish the project? If you don't own the drawings, you're going to need a license to use the drawings, and you're going to have to ask the architect to just terminate it. So it's really important to understand the risks you have if you don't own it, or if you do own it, you clearly state what your abilities are to use it. If there is a parting of the ways and there is a license, you can just say, for example, if I pay you in full for services through the date of termination, I have the right to use. And most architects will require an indemnity, of course, for that use, which just means if, for whatever reason, you use, let's say, design development drawings and use it for purposes of construction, that's not really what the drawings are intended for. You need construction documents to build from. So the architect is actually getting a protection if there's a misuse in that one scenario. I think the only other point I want to touch upon is use of the work product after termination. you have to understand in your agreement what rights you have. And it should not just say copies of documents, because copies of documents doesn't mean electronic documents, doesn't mean AutoCAD or Revit. So you have to understand what the document says you actually own. Many architects typically issue their sets in PDF, and that's fine, that's normal. But if you're expecting that you want the electronic version so that you can use the data that supports that in the future to build from, then you actually need the contract to say it. So understanding this minimizes your risk as an owner, an architect. If they don't want to give up the right to use that, you may have to talk to them about a license to use that in the future. So you really have to understand from both perspectives what the documents provide.
Yes, I have entered the chat. Okay. So obviously part of risk is insurance requirements, and insurance isn't itself a contract because there's types of risk. Obviously there is identification, but also insurance coverage is probably mitigated. So the first thing I always say is you have to work with the right broker to set the right program. And why do I say that? Because you can't, there's many people trying to sell you a lot of things, but you really need to work with somebody who is specialized in what you do so that you make sure that you minimize that you actually can comply with all of these contracts and you're not in breach. So because, you can put in a ton of work on this bid and, you don't meet the insurance requirements and you could put all the work in and be like, oh, I get denied from the pre-qual, but also even more scary from a real life example from one of my clients before they were my client, I should add. They looked at the contracts, they put their bid in, it was a really cheap bid for a good reason, and they did all the work, but then at the end, once they were done, they wanted their last requisition and then retained returned. They looked at the insurance policy and were like, oh, you're in breach of contract. Guess what? We're going to keep your last requisition and all your retainage, which was $900,000. So definitely make sure, even if they say you can go ahead and they let you go ahead, it may give those offshore parties leverage that you didn't know that you just threw away. So they basically work for free. Great, right? No. So that's why I said you got to make sure that you have the right policy and the right broker. And what makes a good broker for you? I always say this. There are three components to making a good broker for you. And there's each, obviously, for a design professional, for a contractor, for an owner, you need to have knowledge, experience, and specialize. Those are the three most important things. Knowledge, when I say knowledge, I mean the coverage, the kind of coverage you need, and the markets that are applicable to that. Like, I don't know if you guys have seen, you ever seen, they give you a renewal package, right? And they'll be like, oh, I went to all these markets, we do marketing summaries, like denied. Well, oftentimes, half of those don't even write in New York, they're just putting it on paper. So knowing what markets are going to be competitive for you means you have to be very specialized in that particular area. Experience is the next one. Like a great example is, Alliance. We're really dominant in the heavy civil space. If you're bidding on an MTA job, nobody's going to know the MTA better than us because we write their whole hosted program. So, we definitely know what they're going to, go step in the heavy civil space. They're going to require, even, on some private developers, we represent a lot of developers, they're going to typically expect, and they are different for each one, so you really need to know that. And as to specialize where, if you're specialized, you're going to have access to more markets. A great example is, your electrician. One's just left the market, but don't tell anyone. There's a new one. They just opened October 1st, and I'm very excited, and they're 30% lower than everyone else. And why I know? Because I have a lot of local free electricians, So most brokers don't even know that yet. So you need to have someone who's well-versed in all three areas. And you don't have to be a broker, because you can't get the coverage you need if you don't get the full picture. So, what was the next one? Problematic. All right, okay. So, you get certificates of insurance, right? We effective, and we always need to do that yesterday, right? So what does that even really tell you? And I'm only talking about this because you were like, my clients just take COIs and they don't care. I'm like, well, what does it even tell you? It's, you know, it's industry standard to approve enforced coverage on the day it was written. That's it. They can cancel the next day and it's absolutely nothing. It's not a legal document. No variant of the coverage provided by the policy. So how do you figure that out? Well, it's a good first step, but it should never be fully relied upon. I'll give you a great example. I have a private general contractor who does interior fit outs, and they gave me, because I do all this stuff, they did like hundreds of these outs, and I was all vetting for them, and they give me these COIs, okay, where's the list of endorsements, please, and this use of interior painting on project. So on the COI, it said, oh, look, they have great limits, it's great. You know what they were insured to do? They were insured as a balloon operator, not even as a painter. So what are they really insured for? Nothing. So it's a good first step, but while seeing the full policies is the only way to ensure there's full coverage, practically what I ask from a lot of all my clients is just at least give me the deck pages with the list of endorsements so I can go through them, just to see if there's anything that's like, you know, oh, red flag, I want to see this one. But also non-negotiable is, you know, I need to see the full copies of the additional insured, the waiver's litigation, primary non-contributory, and the work project aggregate. You know that one.
Yeah, I just like to jump in and say, yes, this is correct. You know, part of the, you know, insurance is risk transfer. That's what it is. It is, you know, assessing a risk and then saying, you know, we are going to determine that an insurance company is going to take on that risk for a premium. And without being able to see the policy, the policy holder or the additional insured who doesn't even, you know, have the benefit of negotiating for or procuring that policy really has no sense of whether it is actually being protected and whether that risk has been appropriately transferred. You know, and I will just say, in an additional insured context, insurance policies deal with additional insured risk in multiple different ways. There are probably 20 different ISO forms that can be attached to the back of an insurance policy, which determine how much risk the insurance company needs to take on behalf of that additional insured. And sometimes it's, okay, you have the same type of protection that the named insured has, but sometimes it is not. Sometimes the policy says the additional insured will only be protected for its own negligence, or, you know, sometimes the additional insured will only be protected for claims that very specifically arise out of the defined working contract, which gets back to what we were talking about earlier in terms of the defined risk. It is crucial to understand the scope of that additional insurance to make sure that it exists, to make sure that you have it. And I'm going to get into this a little bit later when we talk about indemnity, but one point that I cannot emphasize enough, I think if there's only one point that I can make, it would be just because your contract provides that you are entitled to certain coverages or certain things from another party's insurance company. You are entitled to full coverage. You are entitled to select your defense counsel. You know, you are entitled to control your defense and say whether or not you're going to settle. These things being in an indemnity contract or an indemnity provision in a contract do not necessarily translate to binding the insurance company, who may very well say, well, that's great. You know, it's good that you want those things. Feel free to go get it from your partner, but it's not in the policy, and we don't have to do that. And so both in analyzing the available insurance, but also in terms of going back and looking over your contract to make sure you are asking, you know what you're asking for. It's really important to remember that these are separate obligations.
Can I just want to add something there? I mean, not to harp on certificates of insurance, but I think it's a key point that I think what Diana just said is that the COI doesn't actually require the insurance company to do anything.
No.
That if your COI says that you're giving coverage, if the insurance policy doesn't say the same thing, you're out of luck. You have no right, you can't sue the insurance company to enforce the rights on a certificate of insurance. So that's why just getting a certificate of insurance from your contracting party doesn't really do anything to help you. As Mariah said, you want to get the full policy, if not the full policy, at least a deck page, so your broker can go through, see what endorsements are added on to make sure that you are given the best protection available that will help you out down the long run, provide you defense policies going forward.
Yeah, not even that you have the best protection, that you meet contractual requirements that's in your contract, and also for those reviewing it, that you don't get sued. You don't want to get screwed over because you hired someone who's cheap isn't always better. Maybe there's a reason they're cheating. It's usually in the endorsements, just saying. Because good coverage costs a lot more. So, and this actually ties back to working with the right broker to set the right program. Because, especially in the design side, oh my God, everybody gets involved. I can pretend like I'm the expert. I'm not. I have a wonderful lady in my firm who I go to, but she's so good at that. But, because they're the ones who should be helping you. Like, yes, we're talking a lot about this form and that form, but really, where's your broker? They're the ones who should be. That's their job. We get paid for that, right? It's like, we get a commission. I'll say it. I don't care. Like,
If I may add, I think that if you send the indemnity provisions
absolutely.
to your broker,
Yes.
they should be looking at it for you and letting you know if there's something in the provision that potentially might void your coverage, especially if you're a design professional.
Yes, with an asterisk. I'm allowed to technically say, like, for legal reasons, I would be like, hey, if all these wonderful people on the indemnity side are on the coverage side, because I'm not a lawyer, but I on the coverage side, it's a yes, you're in compliance, no, you're not in compliance. But a good broker will give you what I give my clients. It's a risk transfer kit that they can just hand to the subconsultants, subcontractors, so that it makes it very easy, and then we do that for our clients.
Miranda, can I ask you a question?
Uh-huh.
I'm actually curious about hearing you speak. So I see a lot of contracts that people have in a drawer and they go back to them again and again and again. And for example, it might say, this subcontractor has to procure $5 million in general liability insurance, and or whatever number it is, and no one has looked at it, and no one has reevaluated how much coverage there should actually be for a given project. This is somebody might have drafted this in 1988, and there's no. Do you see that?
Oh yeah, I tell a lot of the upstream parties to go kick rocks all the time. That's also part of my job. I'm looking for an LE person that can do that. She's the best at this over there. Go ask her. She's very good at pushing at upstream parties against requirements. A good example of that is one of my clients was working on JFK, and they're like, "You need $20 million of auto coverage." And I'm like, they're not driving around airplanes. What the hell, guys? Like, they're not airside. They go to the employee parking lot and take the shuttle over. Like, shut up. So we got that taken out. We got a carve out for that in the contract. So yes, absolutely how I would ask the question, do I need this? Can I get an exception?
Or even is it enough? Like, right, sometimes it's too much, but sometimes it's not necessarily enough, right?
I'm sorry, I don't think anyone's going to pay for extra insurance. It's expensive enough. I think
From an owner's perspective.
from an owner's perspective, yes, okay. From an owner's perspective, yeah, they'll want $1 billion, I'm sure. Is that reasonable? I don't know. That's a conversation we have.
Right, but I guess my point is someone to be having a conversation to analyze the risk specific to each project,
Absolutely.
as opposed to just saying, this is how much we always ask, and maybe it's absolutely ridiculous from the designer's point of view, and maybe it's ridiculous from the owner's point of view, but it worked at one point.
Yeah, no, definitely. I actually ask all of my clients to give me every single contract before they bid. If they're just thinking about it, even just maybe getting, give it to me, please, please. So it's like, what if you put a bid in and it's like, and at least so I didn't even get the rough. This just happened with another client of mine. They were thinking of trying to bid prime their first one for a major MTA contract. And going from a subcontractor to bidding prime is a significant jump in requirements by about 20 million. So, yeah, so they wanted to know rough estimates about what that would cost. They can factor that into their bid. The worst thing you do is put a bid in and then, oh, by the way, it costs you an extra $1 million. Did you put that in your bid, or are you going to lose your shirt? So I worked with them, and I gave them rough estimates of all the things that, let's not forget, builder's risk for each project has a significant cost, especially on this 3-year project. And we were able to do that ahead of time, because he's not going to buy the limits before he wins the job. What do you want to do? Just saying, that's very exciting. So, but he was able to make sure that his margins were actually really, really sick, even though he did the job, because we gave him set guidance ahead of time so that he knew that he'd be in compliance and exactly what it was. Sort of rough estimates. We can do that just in a day. A good broker can do that.
So on that point, I think it makes a lot of sense. So Dan has said about someone pulling a contract out of their desk and saying, this has worked for 20 years, I'm going to use it again.
Oh, no.
That is the worst thing a contractor can do.
No.
Because every year there are new things that are happening in the construction industry, and that if your contract isn't constantly adapting and changing to protect you from the new risks that are emerging, whether it's tariffs and supply chains, or it's immigration issues and work
They're all
shortages.
requiring cyber coverage, which they didn't previously.
Exactly. So if your contract is not reviewed by your team, whether you be your broker or your attorney, and on a yearly basis, you're leaving yourself open to significant risk. And where the whole point of this panel is here, how to avoid risk. And I think that's an important point to make.
Right. So I get very out about this stuff for like
Well, yeah, and I think, did we hit all the exclusions that?
I mean, I could list a bunch. We all know the labor law. New York's, I call it the New York special, right? I'm assuming everyone knows what that is here. Do I need to give you a live demonstration of what that is? I literally can't. It's the y'all look at me. Oh, you like the live demonstration? Oh, let's go. Okay, so workers' compensation, right? You're an employee, you get hurt in a job, you give up your right to sue your employer because you're being made whole by receiving coverage for all your injuries, and also should you have permanent loss of use, you get a settlement, and in every other state except New York. That's why I call it New York special. In construction contracts, that's 341. You can't sue your employer, but if there are what's called unsafe working conditions, then you can sue everybody else if there's height. And this is where I do the live demonstration, or you can insert a joke. But what height is, so like my thing is like a guy sending 2 paint cans, like there's something, painting the doorway. Oh my God, ow! That was height. Oh, I get $5 million in the smile feature, please. Thank you. So that was my live demonstration of labor law claim right there. So yeah, everybody is impacted. Well, subs aren't impacted by this. They can't sue you, but they can sue everybody else. So that means the owner, the GC, and guess what? Because we sign these contracts and identify people tireless and upstream parties, that pushes back onto you and your general liability policy. So hence why we really need to look at these things to make sure that you have coverage, because let's say you're firing out contributory, waiver of subrogation, and additional insured endorsements don't extend to, the PNC and WS don't extend to the AI. Well, guess what? You don't have any of that coverage, and you can't push it back down. It becomes a new problem. So yeah, there's many exclusions because it is very expensive. The average claim is $1 million about now. And there's a lot of fraud. You can look on anything with fraud. They can tell you all about it. That literally MS-13 and the Russian mafia are actually perpetrators of this. They're taking advantage for 900 seats. And I'm not even kidding. I wish I was. Please check it out. So there's a bunch of different exclusions that they will put under policy, and they'll get creative in the wording. So, you know, the best way to describe it is 100% of owners and general contractors are exposed to this with having zero active negligence, as long as there is something 0.00001% wrong on the job site. So, because liability does not require negligence, and negligence is an act of omission, but these things can be worded like an injury from employee, a modification of the insured contract definitions that eliminates coverage for, that doesn't have the exception that you need, that it does not apply to liability assumed under insured contract. I know this is super nerdy language, I should stop now. But subcontractor, independent contractor, injury endorsements, these are many different ways to make sure that if that happens, guess what? It's, you have to pay for it out of your pocket, which is, I don't know, $3 million?
I mean, I
don't
know,
know.
I check.
The largest single claim for this, somebody got $64 million. So, I mean, I definitely owe $64 million. That would suck. So, I mean, like I said, you can go on for many exceptions.
Media, on to the next.
Yeah, like, I could go, yeah. So, yeah, just, that's why you need a broker, so they can tell you this is bad.
Question for the audience?
Sure.
So, this is going to say, there's rules.
Yes.
Right?
Yeah.
Because there's, so somebody says, oh, unsafe condition, there's no credit.
There's no.
And that's because we live in the state of New York, right?
Correct.
Thanks a lot.
I love to do that. Yeah, that's my job as a New York broker, is I can give all the bad news. It's, and that's, again, going back to the right broker. Because claims are won or lost on the first day, and I better be on speed dial.
It's a broker issue, I think that's the state of New York issue.
It is, and I would love
It's
to.
around and everything, all of a sudden, like you said, everybody's suddenly, what, and then falling right in front of you.
Yeah,
Because
it can be staged, yeah. It's,
that's a broker.
well, it's not a broker problem, but I always ask to be on speed dial, because these claims are won or lost on the first day. And I advise my clients how to best position themselves for, to minimize the impact, to make sure it's $1 million instead of 64. That's the best news I can give you. I wish it would be better, but there are, like I said, iFraud is a great nonprofit organization that's trying to fight these frauds, and they're new within the last 6 months. I would highly recommend checking them out. You can yell at Albany all you want. I don't think they'll listen. I'm being recorded, and I'm probably going to get.
We have looked in line.
This is like stop it.
But there has been a push to make label law 240 unenforceable from the federal level because they're trying to say that it that they'll take away funding from New York if they have absolute liability instead of injuries, and that would remedy the problem for everyone in this room who has 240 liability on the project, because it would either be the law is you can either have the label law 240 and lose federal funding, or you can get rid of label law 240 and keep going. This is the same thing that happened in New Orleans with the drinking age. New Orleans wanted to keep the drinking age at 18, and they threatened that they would no longer give Louisiana federal funding if they had moved to 21, and now, as you all know, Louisiana's drinking age is 21.
Good luck with that.
Yeah. So moving on, I sort of want to take a little bit of a step back and sort of talk about, some fundamental steps that I think every party needs to do when negotiating a contract, whether it's the owner or the contractor or the sub or the sub's sub, because as we know, there are so many different layers and levels, needed to, construct something. And very frequently, what you see is, indemnity obligation being pushed downstream and insurance obligations being pushed downstream. And that's fine and that's good, but it's really important as each individual contract is being drafted, just to take a step back, depending on who you are in that chain. If you are, the lowest level subcontractor who's literally coming in with a pickaxe, to work on a corner of a project, is it feasible for you to be indemnifying these upstream parties and procuring that type of insurance? Now, maybe it's necessary for you to, secure the contract, but, what I see often and what keeps me up at night is a failure to sort of really think it through, to say, okay, I can indemnify, but there are many types of indemnification, right? There is broad form indemnification where you're saying I'm responsible for everybody. There's intermediate where you say, yeah, if I'm a part of it. And then there's a very narrow form of indemnification where you're essentially saying I'm only going to be liable for my own negligence so that you're not. What can you reasonably take on? What will your insurance reasonably cover? I have worked with companies who have agreed to indemnification that their insurance will not cover, and they have gone bankrupt because even if they max out and exhaust their policies, it's $1 million policy that they have bought, and they have somehow inadvertently agreed to indemnify what has turned into a $15 million loss. So that's why I tell everybody, what are your goals? If you're the owner and what you expect is indemnification for everything, the broadest indemnification that you can procure, and you are only going to hire subcontractors and vendors who can provide that to you, that's fine. Make sure that language is in your contract, because many states will not enforce a very broad form indemnification without language that says, no, this is what we need, and everybody understands it. Even in the states like Florida, which is very tough on that, if you've got the language in there that says this is what we contemplate, that indemnification, the broad indemnification, will be enforced, but you've got to put it in. Similarly, and Marie, you talked about this in terms of insurance. If you expect someone's insurance to be primary and non-contributory, and that means the excess as well, not just the primary, that you want full-on vertical coverage of the line, specify that and say that, because there's also law out there that will say primary and contributory applies to primary only. But then you go to, the first party's primary before you go up to excess. Now that's not what anybody means. When you say, hey, you're going to insure me, you don't mean for the first $500,000 and then, the excess tower is not reachable, but you've got to put that language in the policy. It's got to be thought through, negotiated, and specified. Thinking about your goals, and again, it's different. If you're the party doing the hiring and people are bidding to work with you, you have to, you can get what you want. Likely, you've just got to specify it. And if you're the little guy on the totem pole, maybe you can't take this job. But you've really got to think it through and understand who's accepting the risk before you sign the contract, because, having an indemnity agreement in a contract is only as good as the indemnitor's bank account. If they can't pay it, they go under,
That's your problem.
congrats. Yeah, exactly. Likewise with the insurance. If they're like, no, you're not an additional insured, no, we're not covering this, the fact that you've got a piece of paper somewhere saying there's going to be $10 million in insurance is worthless. So think about it. Think about where risk applies in every contract that has, usually it's like 17 and 18. Indemnification is like provision 17, insurance is 18. It's at the end. You've thought of everything else first. You've negotiated everything, and you just want to sign the contract and close the deal. But the problem is, these standard, I didn't really look at them, provisions at the end of the policy are what you're going to rely on if there is a devastating, accident that could affect, the life of your company, everybody's employment, and your ability to do work. So it is crucial, and, that's why the final point, and I've hammered this during this conversation we've been having, is review and update your contract. Does the indemnification, insurance, and additional insurance, language in your contract apply to the project at hand and reflect what the parties expect and intend? And if it doesn't, you've got to change it.
Yeah, and that's something that definitely should be reviewed by, if you have a master contract with, not that Melissa and I've ever done that. They should absolutely work together through brokers. That's your duty. You should always have a good team around you that is regularly reviewing these things.
And I would just add, if the contract requires a defense obligation, if you're a design professional, your PL insurance coverage does not give a defense.
No.
It would only apply under a CGL loss, so you have to really understand what that means, because you might be agreeing to a broader indemnity than your insurance coverage, so it's
Yes.
great point. A
Yeah.
lot of gaps.
Yes.
Yeah.
That's right.
I guess, we have one more slide.
You want to get to yours?
No, I know, it's all last one.
So the last, that was going
Oh, we have one more slide.
One more slide, yeah, that's what I'm saying, that's all right.
Yeah. So here,
What was happening with that reindeer?
There's a very clear way to explain contractual indemnification. In more ways than we're in your ways. I'm glad.
okay, so the last slide, and this is also one of the things you commonly see at the end of the contract, is about liability and how you limit it. And this is really important. If you're an owner, what are you agreeing to limit for your team? And if you're on the team, how are you getting these limits? And a lot of times everybody wants no personal liability. These are our entities, we don't want you coming after us, but you have to understand what the limitation is, if it's mutual or if it's one-sided. You get plenty of these contracts where it's one-sided, and you should at least get the benefit of mutual. Waiver of consequential damages and some carve-outs from that. So I don't know if anyone wants to touch on consequential damages.
No. No.
Basically, an owner is always concerned about what may be additional losses I may have that are not direct damages, and those are called consequential damages. The members of the project team don't want to bear that risk. They don't want to know about your financing, they don't want to know about lost rental income, they don't want to know about, whatever might be categorized under a consequence of damage. So a lot of times there are carve-outs for this, such as, all right, we'll agree to a waiver of consequential damages except if you're, grossly negligent or you have willful misconduct, you set the fire.
That's hot.
So you try to make it work if you can. And you really have to look at these things because they do have implications if there are damages. And last, limitation of liability caps. Many times you'll see in a project there'll be an architect asking for a limit of liability to their available insurance. What does that mean? Well, design professionals have coverage that in the event of a claim, they can have counsel represent them, and their counsel's costs erode the limits. And available insurance may not mean the $2 million in coverage that the contract says they have to maintain. It's $2 million less the attorney's fees eroding, and then you get to trial, and then what money is left. So you have to understand what all of these things mean. No one can tell you what's right or wrong for your project or your scenario, but you have to understand how the risk is being transferred to you, or how you're transferring or mitigating your risk.
So on the waiver of consequential damages, I think that's a really smart point, and that goes back to knowing what your contract says, and you can use the same template contract, because most of the buildings in New York are either high-rise office buildings or luxury condos now, or apartments. And there's an issue that there's no rent for a certain, let's say there's a delay of 6 months, that 6 months the owner's going to claim they could have rented the space out to an office, or they could have rented it out to available for housing, and that's 6 months at whatever the rent for one of these offices are, is $20,000 a month. That adds up quickly. So knowing knowing the work you're performing, what kind of building you're doing the work for, and tailoring your contract to protect yourself based on the work you're actually doing, not on the work that you did in 1997 when you drafted your contract, is really a key. And I think that's really the key. I think we all wanted to stress, and it's knowing what your contracts say, drafting them, staying on top of them, making sure your risk is always taken care of, and you can avoid lawsuits, so you don't have to call the lawyers up here.
So the takeaway is talk to your lawyer and talk to your broker.
That's a better way to
And
put
they
it.
should be
Yes.
besties.
I think that's.
Are there any questions?
Next slide.
Oh, there's more slides? Okay.
Sorry. Yeah.
Okay. Now there's questions. We have it just went red, so it scared me. I'm sorry. This is everyone's contact information up here.
What, I may or may not have definitely contributed to the
graphics
on this presentation, yeah.
Yes, if you like the memes, the Instagram handles that Brandon pulled them from are all cited. So
Maybe up, you want some real bangers.
does anyone have any questions? Everyone else?
Thank you.
Thank you.
A growing number of clients who have experienced social engineering and deepfake losses. More so than, maybe pre-COVID when it was more brute force hacks. Now we're really seeing phishing, wire transfer fraud, and with regards to these things, I can tell you from experience that the insurance companies will raise coverage defenses if the clients do not comply with the conditions of the policy to a T. And oftentimes, if that doesn't happen, that compliance beforehand, it's because the policyholders didn't read the policy, didn't incorporate those things into their standard operating procedures, and then you're potentially facing this uphill coverage battle with your insurance company to try to recover on those claims under a policy that you paid to protect you in that very circumstance. Now, for example, when we talk about social engineering, one of those requirements that I've seen in a lot of policies is if you have a wire fraud claim, the policy may require you to do a callback verification before you actually effectuate the wire transfer. So what that means is you have to pick up the phone and call whoever it was that you think sent you that email, your client, the company, and verify with them, hey, did you just send me new wire instructions? Because I got this email from you, I just want to make sure this was you. And you have to do that before you actually send it, and if you don't, and that requirement is in your policy, then you're potentially facing a coverage denial there, and you're going to have to fight with your insurance company on that. Now, the reason the insurance company does this is because it wants you to exercise some diligence. They want you to be vigilant and look into these issues to try to avoid a potential scam and to detect them. The problem there is we now have AI. And with AI, it is so much harder to detect those scams. And I don't know if you guys heard about, sometime last year, about a year and a half ago, there was a company in Hong Kong, and an employee got an email from his CFO saying, we have this secret transaction, you need to transfer $25 million. So he was reluctant. He said, this sounds like a scam. This must be phishing. But then he got on a Zoom with the CFO. And not only was the CFO on the Zoom, but there were other coworkers on the Zoom who he knew who were on there, and they were all talking about this secret transaction. So any concerns that he had before that Zoom call about this is a scam, this is phishing, Those were put to rest when he got on that Zoom, spoke with the coworkers, spoke with the CFO. So he transferred the money, $25 million out. Guess what? Everyone on that call but him was AI generated. The conversation, the faces, the discussion, the entire call was fake. He was the only human on that call. But it was so convincing that he transferred out $25 million. I mean, this is scary. And these are the risks we face today, and it's not just big companies. It's small and medium-sized construction companies. Oftentimes, the bad actors look at those as low-hanging fruit because they think, well, these smaller companies are not going to have the rigorous cybersecurity controls that the larger companies have. And so they go after them because in their minds, they're easy targets. And that's what we're here to talk about today. We're here to talk about those risks, how you can potentially mitigate them, and what insurance is in place for those. Before we begin, and we have an esteemed panel of experts here from the construction industry, legal, and insurance. But before we begin, I would like the panelists each to briefly introduce themselves. And look, let's start with, there we go, Jessica.
Hi there, good afternoon everyone. My name is Jessica Mora. I am with the Shore Partners Gallagher. I focus in the construction and real estate verticals in New York City. I've been working as a broker for 9 years. I'm actually a part of the National Association of Women in Construction as well. We support the WBC group. I'm very excited to be here to just share, I guess, my perspective, right? This is all legal, so they're at the end when the claim happens, and I'm at the beginning. So hopefully, between all of us, you'll get a good idea of what you need to be doing to prevent some of these issues.
Thank you, Jessica.
Good afternoon, everyone. My name is Deirdre Foley. I'm in-house counsel at Insignia Construction. We are a construction management firm. We do work as far north as Portland and Maine, as far south as the USVI and the Caribbean, all up down the East Coast. I've been a practicing attorney for about 11 years. I've been with Insignia for about 2, and I'm very happy to be here with you all today.
Thanks, Deirdre.
Hey, I'm Bridget Quinn Choi. I am with Woodruff Sawyer, also a Gallagher company, new colleagues here. And in my role, I am on the product side. So I write the insurance products to help enhance them and make them fit for our clients. And my background is a little different. It's I'm an attorney by trade, practiced law here in New York City for 9.5 years. Then I went in-house in an insurance company, and I was both on the claims and underwriting side, and I really learned a lot about how the inner workings of insurance work, and really I focused on cyber claims. So I've seen thousands upon thousands of cyber claims. I pivoted over to consulting, where I was the director of incident response and resilience for Booz Allen Hamilton, maybe you know them, one of the largest government contractors in the world. And our practice really focused on being the firefighters, putting out the fire, and then getting companies prepared. So what I like to say is I bring a 360 view on what you need to do to get a risk transfer and get prepared.
Thank you, Bridget. Okay, so let's dive into the current threat landscape. So, Deirdre, you're in-house at a construction company. What are some social engineering risks, deepfake risks, that construction companies are currently facing now that you see?
Sure. So more often than not, we are seeing a lot of risk come over by way of email. And a lot of this is intuitive. Construction is a hyper fact-intensive industry, and so these risks are mirroring that. These email, with email being the primary form, they're also quite fact-specific. Attackers can pretend to be, they can pretend to be Consignia, they can pretend to be us, they can pretend to be a subcontractor, a client, an owner, a government awarding authority, and these spoofed, the the spoofed communications can range from fraudulent invoices to fraudulent requests for proposals or fake change order approvals, and really more often than not, you wouldn't be surprised, they're targeting project payment workflows. And they're patient actors. They will take their time, they will fish for application login credentials. If any of you are familiar with, for example, Textora or Procore, attackers will first get into your project application software, and they will wait, and they will watch, and they will observe the cadence of any given project's financials. So they will see, we can expect client XYZ to be submitting or paying out a change order on the 25th of every month. And they'll give it a few months, they'll watch that pattern emerge, and then they'll execute on sophisticated wire fraud scams, for example. And as technology keeps evolving and garnering more and more advantages for the CM side of things, you always see an element reminiscent of cat and mouse, right? As the technology evolves to our advantage, so does the risk evolve. And more often, especially with the advent of AI, as much as we're benefiting from that, so are the bad actors. To Luna's point, the generation of that Zoom scenario was particularly advanced. We've seen amongst our peers with much more frequency AI-generated voicemails from CEOs. We've gone beyond the likely familiar anecdote of a CEO calling, emailing a summer intern saying, I need $500 of Apple gift cards to Stats, and I don't have the cash, a multi-million-dollar operation, and he's relying on the summer intern. But really what we're getting now is much more convincing, and construction is so fast-paced, and folks are used to moving at quite a clip, that it's normal for a certain exigency to be layered over these types of interactions. So the biggest challenge that we face is that these cyber attacks don't look as simple as they used to, with 23 digits strung together with a Hotmail email address saying on this link, grandma posted a photo, and et cetera. Now they have your email access. Now it's much more often identifiable only after it's too late and after a fairly significant financial loss. And particularly problematic for an industry that's relationship dependent is that something that could fall into the category of intangible damage is loss of reputation and the erosion of relationships. So it's certainly a multi-factored source of risk.
Are construction companies using the AI to their benefit to also counter it? I know you mentioned AI has increased the sophistication of the attacks. I also assume frequency, but you also said it's good and bad. So have construction companies been able to use AI to their benefit to thwart or uncover attacks?
It's a great question. The answer is, as you would expect, that defensive use is cropping up now too, the other half of that cat and mouse cycle. And as you might expect, it's market driven, right? When entities realize there's a space in a market to profit from the protection or the defensive use accordingly, that void will be filled fairly quickly. So the short answer is yes, defensive use is coming back.
What about how are construction companies targeted? Are they targeted directly? Are they targeted through vendors? Does it depend on the nature of the attack?
It's a great question. The unfortunate answer is both. We're getting attacked on all fronts in this realm. Awarding authorities, particularly, for example, municipal entities with fewer or less resources to dedicate to cyber liability, are outside the purview of our protection. So, for instance, owners may require that we use third-party software or a third-party vendor simply to make payments, and we have no control over the cyber health of that third party. And we're also faced at the same time with an intersection of considerations where using a more well-buttressed system or using a different system at all may come at a price. Where CMV is typically in the single digits of a percentage of a job, and to use a more reliable system as a whole 1%, that's a significant business consideration for a CM or even a sub. We're seeing smaller subs who are similarly less sophisticated or with fewer resources at hand, facing threats as well. And if you get into a sub's financials, you'll find this eventually. So there's also the element of what I think is particularly clever, unfortunately. With public projects, there is a lot of information out in the ether, from bid documents to permitting. And in addition to the use of AI, there are just old school facts out there that can be mined and, you know, really well integrated into the tapestry of a particular relationship dynamic on a project. And again, patience is key to profit off of an attack like this. You kind of you change one letter in email address, it's fairly indiscernible with an established relationship. You bring in a new actor, and you reference a very specific permit, for example, and all of a sudden defenses are down on the receiving end, and you found a way in.
So, Bridget, I was wondering if you could talk about how these attacks are orchestrated and walk us through some of these fabulous slides that you've prepared.
So I wanted to put this one up as what I'll call come to Jesus. These attacks are happening. They're costing companies billion with a B of dollars. It's not getting better. And you have to have what I'll call a layer of defense, which is operational, cyber technical, and training your people with cyber insurance. So you need the risk transfer that's appropriate and that your needs, along with the governance internally. So I'm not going to go through this because I think they're arresting as they are. The attacks are up, carriers are paying out the nose. Luckily for you, it's still a soft market. So while losses are growing, AI-enabled attacks are making it easier for the attackers, more convenient and quicker for them to get a turnaround, there are things you can do. So just go to the next slide. What I wanted to show you is how a typical social engineering attack occurs. And social engineering is just a fancy way, it's a working term for theft by trickery, right? We all know what theft by trickery is. We tricked you, we took your money. And you're going to hear things like phishing. You're going to hear business email compromise, deepfakes. All these things are just theft by trickery. And in this attack, it was a phishing email. So a malicious email that comes into someone's inbox. It redirects them to go to a phishing page. So maybe a link said, hey, this is IT. Can you fill in your credentials so I know what they are? And what the attacker does is it sucks up those credentials. It sucks up any other information you take off of your browser. And then it takes that authentication. It takes the cookie from the browser and it goes directly into your email. And boom, you're in. That easy. And with AI, those phishing emails are very convincing and easy to execute on. Before, we'll say 2019, the attackers used a methodology called spray and pray. So they would spray out tons and tons of emails, just pray someone would click on it, and once they did, they reeled in the fish. The attacks are much more targeted. Right? A new deal proposal will go up, some sort of news clip will come out saying a new project is being built. That will trigger them to start hunting around for the companies who are bidding on it and start targeting attack. They say some of the biggest times that a
companies fish is if there's a merger and acquisition or some sort of public news saying they're doing something new, they want to bid, something along those lines. And if you don't think that they're trolling industry publications, they absolutely are, because they can go to Google over it and it'll come right to them. They don't have to do anything. AI has enabled them to do their business very, very quickly, easily, and conveniently. That's it. What I wanted to show you was a depiction of how easy it is to do a deepfake, and the difference between the slide you saw before, which took a couple of steps, and just something that's really easy. So we've talked a little bit about phishing or voicemail phishing. We talked a little about phishing where you get an email in your inbox. How easy is it for them to pull up? Well, I will tell you there are several malicious apps that are available to these threat actors that you can download. Any teenager can do this, honestly, half of them are doing it already. If you have a clip of your CEO at any point or your CFO on the internet, they can pull that, or easily enough, they can do a call to you and talk to you about anything. Record that conversation, throw it into a voice cloning synthesis app, and boom, the attack is already there. They use WhatsApp or Teams frequently, from what we're seeing, and they could go on camera, they could not. A lot of times they don't. And what they'll do is they'll call different people in who process, anybody who processes payments. And they'll say, we have a really busy thing, this has to be paid now, here's the account I want you to work to. And it will absolutely sound like that CEO, CFO, person of authority. It is easy to do. And one of the risk controls, there's a lot of risk controls that you can put in place, and we'll unpack that a little bit more later. But one of the things that you should be advising your executive board and those with power within your organization is the use of personal emails and WhatsApp. Don't do it to your employees, that's for you only. And educating your employees, if you get something from WhatsApp or personal email, do not respond to that. That is not from your executive, that could be a clone fish. It's one of the red herrings that's new, that isn't necessarily trained, and it's one of the red herrings that is easy because honestly, the CFO or EO Gallagher emailed me, I'd be like, no thank you, he has no business talking to me.
And that would respect you because he understands that there's protocols in place.
Correct.
The real CFO understands.
So one of the things that I wanted, we talked about phishing, smishing, business email compromise. I wanted to categorize what is the next part, which is what is the end result? You're going to see fraudulent transfers. And what that is they trick you into getting account passwords, banking information, and then they directly pull that information right out of your account. Everyone, this is a public service announcement. Your retirement funds are definitely under attack. Put some MFA on that. Fraudulent instructions. Hi, I'm the CFO. Can you please wire this not to this wire account, to this account? So changing the accounts to an exotic account is another way. It's called fraudulent instruction. And the last means that we're seeing is invoice manipulation. So phishing email comes in, bad guy gets access to person of authority's email. They'll go through the emails, they'll change the rules, and they'll start throwing out malicious emails to all of your subs. And what those emails will be, hey, this invoice wasn't paid, or we didn't receive this. Can you send it to this new account number? Guess what the new account number is? It's their account number. So we're seeing a lot of that. These are the three common methods. There are other methods out there. There are other ways that they trick people. But first thing to do in an organization is understanding and recognizing the problem. The next steps are addressing them through governance, tools, and insurance.
Great. So let's talk about insurance now, and then we'll circle back and talk about internal controls. So, Jessica, do construction companies typically carry insurance for phishing, social engineering,
But sadly, that's a strong no. The statistics are basically 50% of construction companies in the United States don't have cyber liability coverage or crime policies in place. And unfortunately, it's just continuously getting worse, so no, they don't.
Is this something that can be bought and added to existing policies that they traditionally purchase?
Yeah, so, it's funny because when I have conversations about ancillary coverages with contractors, typically the response that I get is, if it's not required, I don't need it. And so I can't tell you, but that sentiment is all across the board, and it's a shame because this is going to cover their operations and it's going to keep their business going. The two policies that they would absolutely need to have relative to this panel is going to be the cyber liability and a crime policy. And you have to be careful because not all policies are made equally. There's going to be limitations to the coverage, the forms, the insuring agreements. And so you want to make sure that you're working with your broker, like Miranda suggested, and you're having conversations with them to read the policy language with them, right? Have them talk you through the language so that you understand what those insuring agreements are and whether they're applicable to your business or not. And if you have a cyber liability policy already in place, I would say supplementing with crime. I don't think that I will come across, as I talk to the people, they just don't have these ancillary lines. And the crime one is particularly wonderful to have if you've been breached because of the limitations on the social engineering. So a typical cyber liability policy is going to have, let's say you have $1 million policy, there's going to be sub-limits for social engineering, and the maximum is $250,000. So if you get a crime policy and you have the insuring agreement for social engineering and computer fund transfer, you can have additional limits there. But you need higher limits, you might need to go and buy that separately, right? Because it's not always available.
And that's a really important point because I've had clients who call me and say, I have $5 million crime or cyber policy, and they had a phishing attack, but then we look at their phishing endorsement and it's sub-limited and it's never enough. Can you talk about sublimits and how that affects the policy and the coverage that's available?
In my experience, I think that what happens is that a lot of insureds, just people in general, don't take the time to read through the policy language. You have to take the time to do that with your broker because there are many different limits set aside within the limits. Just like a general liability policy limits erode when we're talking about defense, the same thing is applicable to a cyber liability policy, which can have many different items that would be covered just under, for example, first-party coverage. You're talking about regulatory fine, out of $1 million. Regulatory fine comes out of there. Notification expenses, the credit monitoring, forensics. Do you know how quickly $1 million can go just on that? So it's incredibly important that you are talking to your broker and maybe getting some data to help you choose the proper limits so that you have enough coverage to pay for all of those things. And sadly, a lot of the time people think that we're just trying to sell an additional policy, but that's not the case. Our roles are to educate and to advise you on trends and things that are happening in the industry, and this is not a want to have anymore. You have to have a cyber liability policy in place. You have to, because of the way technology is moving today.
So what about if a company is targeted through a vulnerable vendor or supplier? What can you do in terms of insurance, protection, or risk mitigation to protect yourself from that? Because you've done as much as you could do in your power to have your controls rigorous and in place, but you can't control what your vendors do, and they don't have anything on there. So how do you protect yourself in that
You
situation?
know, that was an interesting question, right? Because if you think of the ecosystem for a business and how many vendors a business uses on a day-to-day basis, right? It's not just contractors here, guys. We're talking about the full gamut. Your CPA, your bookkeeper, your project management system, your payroll provider, your time and attendance, your supply houses. I mean, you're talking about everyone here, and I can guarantee you that most times you are signing some sort of an agreement with all of these companies. Who is reviewing that for you? You should have an attorney that is going to be on your team, that's going to be representing you, and that's going to be having access to any contracts that you sign. Contracts are not just construction contracts. Contracts are all across the board. And so what I like to talk about is making sure that you have those standards in place for your company, and that those standards are then extended to any third party that you're contemplating to work with, and that those same standards, that they are adhered to, and that you have to do your due diligence with them as well, that they are meeting at least the baseline. How many IT companies, a third-party IT company, I can tell you because I have clients that fight me on this, they have an IT company, MSP company, doing their network security, they have no contracts in place, and they don't even have a cyber liability policy in place. So if they get breached, which by the way, they are the number one entry point or one of the most targeted classes because of the access that they have, if they get breached, you're screwed. So you definitely want to have a standard in line for your company. You want to extend that practice to your vendors. Training is critical, so it's an investment that you make in your business. It is something that is critically important for you to stay, competent or not competent, to stay relevant in the business. Training your employees, having them go through simulation attempts, right? Like teaching them what that looks like. In addition to that, the last thing I would say is super important: incident response plan. So you get breached. What should you do? Freak out? Who you gonna call, right? It's really important that the C-suite and or owners have some sort of a plan in place with key people in management that know and understand the processes and the steps needed to respond to an incident, because the longer you take, the worse the claim gets. So you want to act as quickly as possible, and you want to have some sort of documented, written plan for an incident so that everybody understands what to do if there is a breach.
And if I could add very briefly, I think you make a very good point, in particular that last one. This is my gentle plug to buy your IT department lunch. Cross-departmental collaboration is key in developing an incident response plan. Oftentimes, it's very natural to be focused on our own sphere of work, but really bringing in those other perspectives to lend a multifaceted approach to solution building is key. When something bad happens, stressors are high and cooler heads prevail, it's much more likely to have positive resolution all around when you've prepped, you've brought multiple minds to the table and working together.
That's a great point. And just to add one last one on that, and we've kind of transitioned into control. So I want to ask Bridget a question, but I would say also make sure you have your incident response plan available in a hard copy and accessible in case you happen to suffer something like a ransomware attack and your whole system gets locked and everything is saved electronically. You won't be able to access
You'd be
it.
surprised, by the way, the insurance companies have so many resources that they're willing to give you, but you probably don't even know it because you didn't even read the policy or your broker didn't tell you. But the broker also has resources that they can give you to help you put one together. You're not alone. You have a lot of people that are willing to help and to give you the resources to put one together so you have something in place.
Yeah, great point. So, Bridget, we've started to talk about internal controls that a company can put in place to better protect themselves from a cyber attack. Can you speak specifically to social engineering fraud, especially with the proliferation of AI, and what can be done on that end in terms of controls?
Yeah, on the slides, really governance.
actually just put in place from an operational standpoint. It'll slow you down very slightly, but it will make all the world of difference. So mandatory callback protocol. Your CEO says make this transaction. Call back on his cell phone, call back on his work phone. Make that clear, make that operated to be tested. Because if you call he or she back and he or she says, hey, I don't know what the heck you're talking about, you just, from a human standpoint, caught a very complicated attack, right? We talked about this in the beginning, about a condition precedent coverage, right? The conditions that happen before you get the social engineering coverage. One of them is going to be dual authentication controls. So what they're going to say is two people have to authenticate to the bank or to the supplier that this is indeed a legitimate invoice. You have indeed wanted this account to be changed, and this account indeed belongs to the construction company or the vendor to whom you are sending the funds. This takes some time. This will take a solid 10 minutes. And if you're doing a lot of transactions, this is difficult to enact, but it absolutely saves millions of dollars. It's something that you can put in, and it will help you trigger your coverage because most crime or social engineering coverage grants will have this either as an underwriting control or written into the policy as something that you have to have in order to trigger coverage. Education and AI awareness training. Okay, so I know in construction it's not necessarily something that's part of the culture to do cybersecurity awareness training on regular, or maybe phishing training. But I will tell you, it does open up eyes to behaviors. It does give your IT or your CTO some sort of understanding who's actually learning and who's just clicking through their email on anything. So these trainings do change. And the last thing that I want to point out is that financial fraud kills you. We make mistakes. There is a way to freeze the funds once you notice, oops, I sent you the wrong. And underneath, it has to be above 50 grand, which unfortunately many of them are. Wire fraud for the FBI has to be international. Secret Service, if you call them, it's within the United States. And they can recall those funds and freeze the account from which it's sent. So if you're on top of where your transactions are going, there are ways to stop it. But if you're not implementing any governance, it's going to be very hard to combat this, particularly with social engineering making these attacks more frequent and more convincing.
Just to follow up on one thing you said about dual authentication, what I've noticed with client claims where they settle with the insurance company, lately what I've noticed is the insurance company wants to send a check. They don't want to do a wire payment anymore because it's a pain, because they have to do the dual authentication. They need two people, they need a call, they need an email. So now they're asking, can we send a check to a physical address? And clients are like, wait a minute, I'm still hybrid, what do you mean a check? So it's interesting to see that that's where insurance companies are going with it. And I'm kind of curious even where the coverage is going to go for policyholders in terms of, wire transfer fraud coverage.
I was just going to say one quick thing. So we talked a little about AI technology that could be implemented. A while back, Visa and MasterCard created a machine learning AI way to identify within your banking system fraudulent transfers or risky transfers or things that look unusual, and will freeze them. Now and it was pretty extensive and it's really for banking, but now this, with AI that's proliferated
There are smaller companies that you can put this on, it's not that expensive, and they will monitor transactions. In fact, there's an insurtech out there that if you buy into it, right, you buy the policy and you buy into this extra offering, they will monitor your transactions and they will alert you immediately when there's a fraudulent one. So there are ways, not just operational, there are technological ways that you can monitor transactions that make the ease of doing business easier, and the culture of construction with quick payments manageable. But you have to know, and you have to think about it, and you have to implement it, and you have to audit and test it.
You know, with dual authentication, something that I've found when I'm talking to clients about this coverage is that oftentimes I've seen other brokers completing these applications on behalf of the client, and people who have no idea filling out this application. Now, this application is a warranted application, which basically says that you are guaranteeing or warranting that the information you're saying you have or the controls that you have in place are in place, and that's where the coverage also becomes a thing, right? And becomes a coverage trigger. So when the claim comes, the client is going to say, oh, well, this control is supposed to be in place because it says on the application, which is made part of your policy, that you have that, and then you don't.
Yeah,
And that is a huge problem that I see when I'm talking to people. And it's like, you know, they want to just say yes, 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 just to get the quote, but then when the claim comes, they don't have the coverage. So that's something else that I've seen, and my claims, you know, potentially don't go covered.
Yeah, that's a huge issue that we see, unfortunately, all the time. If there's anything wrong in that application, the insurance company may raise it as a coverage defense. Unfortunately, in New York, an innocent mistake can still constitute a basis to deny the claim if that mistake was material, meaning the insurance company relied on it in selling you the policy. It can also give rise to an action for rescission where the insurance company would void the policy as if it never existed, because they're saying, well, we relied on the application, we relied on the application, and we would have never sold you the policy had we known the truth. So that comes up all the time. And you definitely, especially if you're getting cyber insurance or anything regarding technical, cyber-related, cyber crime insurance.
All risk coverage. So they're going to cover you for all risks of physical loss or damage to your construction project unless it's specifically excluded. If you have a loss, say you're 70% under construction, you're just about to get ready to open up, you're feeling good about the project, and something comes through, a hurricane, a fire, some other loss, it sets you back, right? You're going to need money to get back to where you were in the project at the time of the event, until there's risk coverage in place for that. And then there's also certain time element coverage, which gets you in a second. Going back to the property damage portion of it, important to note that this typically includes the overhead of profit that an owner is paying to his contractors. The policy may specify the overhead of profit percentage, or it may say it's not to exceed the amount in the contract, right, with your contractor. I've seen disputes in this area. Typically, you're able to work them out. Your coverage is going to extend to materials and equipment on the site, more typically, as long as those materials and equipment are intended to become a permanent part of the project. And then there's also key coverage for expediting and extra expenses, right? Everyone has an interest in getting you back to the point you were before the loss as quickly as possible. Why? Because your delay in startup claim, right? This is a very important element of your coverage. These are commercial projects. They are intended to produce revenue. The longer you are out, the more of a delayed startup loss you have. You're not making the money that you intended to make. So the policy will pay certain expediting and extra expenses for you to essentially make up some of the schedule that you lost. Some of these time element coverages, things like soft costs, right? You're going to have continuing interest on your construction loan, that could be covered, real estate taxes, additional architectural engineering fees, numerous different subcategories of soft costs that you're going to incur because of this loss. Rental value or business income, if you're a commercial or residential real estate project, you typically have a rental value coverage associated with that. If you're any other kind of income producing commercial project, whether it be manufacturing or some type of energy plant, you'll have business interruption coverage. These are not necessarily standard coverages. You have to purchase these typically separately. So have a discussion with your broker and talk about what's right for you. We call these coverages time element coverages because they provide coverage for a period of delay. And that period of delay typically is the difference between your projected completion date before the event to the time that you actually complete the project. Now, as you can imagine, there's all sorts of disputes that come up with those issues, right? Everyone's talking about concurrent delays. Well, you were behind schedule to begin with. Maybe you should have made more schedule up. That is a hugely complicated area. There are people that specialize in these project scheduling that can support your business interruption claim, people in this room, in fact. So, very interesting area. But I hope that gives you a little bit of groundwork, at least for what builder's risk coverage is, if you aren't already familiar with it. All right, now I'll stop talking for a little bit. Let's talk Ellen. So, what is it about climate change risk that throws such a curveball to design professionals, especially when it comes to urban infrastructure projects?
I think there's a bigger question.
Good. I'd like to ask fair question.
Yeah. So let's first look at New York City as a client, or New York City as a place to do business, and how climate adaptation is driving so much of how we are all working in New York City. Because what we're seeing is not just compounded risks around climate change and climate mitigation in our projects, but we're seeing cascading risks. So for example, we're seeing 3-year delays associated with delivering capital infrastructure projects to New York City, and those delays are weather related. I mean, obviously there's all these procurement issues and things like that. What we're seeing builders go in to build a apartment building in Brooklyn, and that apartment building in Brooklyn is flooded 3 times before they can actually put walls of that building up. So what are the impacts of that? Not only just from construction, but to the neighborhood as well, right? So that's what we consider to be a compounding risk in developing that project. Additionally, we look at the waterfront of New York City. So there's a big drive, everybody knows there's lots of projects going on around climate resiliency in the city. We've got East Side Coastal Resiliency, we've got the Battery, we've got what's going on in Coney Island, we've got what's going on in Jamaica Bay with the Army Corps, and all of these areas are areas that are predicted to flood or be underwater by 2050. So we're making major investments in infrastructure in the city and assets that probably no longer be viable assets in the next 25 to 50 years. So what does that look like in terms of a builder risk, right? What does that look like in terms of an owner risk? How does the city take on those sort of onerous concepts around climate mitigation and climate flood mitigation when we're talking about things like a builder's risk? So I think that it's really important to look at this from like a pretty high level when we start this conversation, then we can get into things a little bit more granularly as we progress.
Yeah. And what are in terms of forecasting or long-term impacts in how has climate change played a role in that?
Well, it's a major role, right? We think about climate impacts as the impacts we see on a daily basis, but to go back to a building site, so New York City has had its highest average days over 105 degree heat index. Anybody who has materials on their site are going to see significant warping of that material and general great degradation of materials on their job site. So we're looking at not only just a procurement issue there, but you're also looking at a safety issue in terms of how they're handling those materials. And then there's things like how it's affecting the order of operations. And we've just had great conversations around insurance, right? So how do you insure for a crane when it can't be put up for over 3 weeks to weather-related impacts, right? So that's not just affecting your bottom line, if you're on the private or on the public side, but it's affecting everybody's bottom line as it trickles down throughout our economy. And I think those are like the bigger, sort of softer risks, but the harder risks around it are how many people can get to their work location, right? So in 2025, we've had an average of over 3 major 100-year flood events. That's 100-year flood events in New York City. And when we think about what those risks do to us on site, it's not just our materials, it's people getting to the site, it's people not being able to drop their kids off at childcare to get to the site, right? So suddenly these risks are compounding exponentially. And we see that on the city side, and we see that on the private side as well.
And so in terms of, like trends, what are you seeing is the trend now in terms of design strategies for dealing with climate-related risks on construction projects?
There is so much going on in the technology space right now. There are companies working on predictive modeling with organizations like NOAA, where we can actually, within 50 feet of an event, be able to forecast exactly where that rain is going to hit. So what's interesting in New York is New York's never had a flash flood warning. We just had one in July. The very first flash flood warning. And what that did was it picked out a lot of the infrastructure, the soft infrastructure that we put in Jamaica Bay or at the Rockaways Coast Sandy. Those kinds of design risks we incur is that the agencies come back to us and they say, your design didn't work. But your living breakwater, your coral reef that everybody was so excited about failed. And then we made these massive infrastructure investments, and key as those massive infrastructure investments are in line with what the real estate industry is looking to develop as well. So then we're looking at a massive cascade.
What are some of those systems that you're starting to see put in place, things like flood barriers and things like that?
We're seeing a lot in flood barriers. We're seeing, has everybody heard of cloudburst technology? So cloudburst technology is being used throughout the city. It's when they take a sunken basketball court and they make it so that it can hold up to maybe 3 inches of rainfall within a 2-hour period. So that way that neighborhood doesn't get inundated. But the technology and the information is also moving really quickly. And I think that it's important to say that, climate change is introducing so much into our dialogue and how we do business in New York. How to mitigate that risk is the big question. There is no way to singly handle this. And if there was a magic bullet, we all know it right now. I think the design, the best that we can do is forecast out what would be the worst case scenario. But as we predict that out on a coastal surge, when we displace water in one place, it goes to another place. So we're displacing water in Manhattan, it's going to impact the world. If we're diverting water in Staten Island, it's going to impact Jersey. So these are all pieces of the design risk that we carry. And I think that we're starting to see the city council, we're starting to see the drumbeats around climate risk insurance as a mitigating factor in our contracts.
So try to tie it into insurance. So we have all these climate-related risks to building projects from a design and planning perspective. And how should owners and contractors really be thinking about builders' risk coverage?
Well, I think it's a force majeure issue, but I'm not an attorney, so I'm not going to talk about it. So we've got two really qualified attorneys right here, so they can speak to that a little bit more than I can. I will say that there's massive disparities within the insurance models for flood than where we are now. The engineering industry and the construction industry are way ahead of where those models are at. So when you do get insurance, you may not be getting the insurance coverage that you need because their models, their actuarial models are actually behind where we are right now. Also, it's such a vast changing landscape. New Jersey just changed their flood rules. They're actually higher than what the Army Corps has and FEMA has. And that's really affecting how you do business in New Jersey. It's also creating a migration of people and a change in where we're living in these areas as well. We as providers of housing and schools and roads and all of these kinds of things now we're looking at this migration, this climate migration, how we mitigate those factors in how we build cities.
So let's talk about some more of the nitty gritty when it comes to building risk coverage. Named storms, right? Obviously a very significant risk for construction projects. We're talking about your hurricanes here mostly, but not exclusively, because the National Weather Service has a certain penchant for naming everything these days, and it can be dangerous under insurance policies. But named storms is one area where most builders risk insurers will try to limit their exposure. And one of the ways they do this is to charge a higher named storm deductible. And this is typically expressed as a percentage basis of your total insured values, right, your TIV. There's a lot of confusion as to how it is supposed to apply, and this has played itself out in some cases. So take this hypothetical, for example. You have total project values of $300 million. You have a named storm sublimit of $100 million, right? So insurance companies recognizing you have a very large project, it's worth a lot of money. We're not willing to take on your full $300 million in risk due to named storms. We're only willing to cover you up to $100 million. And by the way, we're going to charge you a 5% deductible. 5% of what, you ask? 5% of the total insured value. Well, does that mean 5% of my values at risk? And the value at risk is what? It's $100 million, right? Because that's all you're willing to cover me for. Or is it 5% of the total values that I declared for the project, the full $300 million? And there's some cases that go both ways on this issue. Florida is more policyholder friendly. The case cited there, Terra Hattie intern, was a builder's risk case. It was a couple of real estate projects going on, Miami-Dade County, Florida. Katrina hit there. They had a 5% of total insured values at risk deductible. And the court said, well, I get both arguments. I think they're both reasonable. And that means that your provision is ambiguous. And because you, the insurance company, drafted this ambiguous provision, we're going to insure it in favor of coverage. And so that one worked out in favor of the policyholder. Fast forward a few years later to Castle Oil Corp, which was a fuel oil terminal here in the Bronx. It got flooded in Sandy. This was not a builder's risk policy, it was a commercial property policy, same concept. It had a 2% total insured value at risk language for its deductible, its named storm deductible. And the lower court actually agreed with the policyholder. Interestingly, the court did not say that it thought the provision was ambiguous. The court said they thought it was clear, the policy was clear. The amount at risk is what they're willing to pay for flood. And so you pay the lower percentage deductible. But it went up on appeal, and the appellate division reversed. It also said it was unambiguous. So unfortunately, the court felt it was unambiguous that total insured values meant the total insured value for the project. So with these types of disputes, these insurance coverage disputes, they are driven by state law. And what state's law can the outcome determined. So whenever you have an issue like this, you have to pay very close attention to which state's law might apply.
Yes.
Yes?
I have a question.
Oh, shoot.
You mentioned Florida.
Yeah.
Florida's being a massive insurance retreat.
Yes.
How do you think that this plays into what you were just saying?
Well, terms, there's no question. Terms across the country, but especially in Florida, are getting harder and harder. I know there's at least one builder's risk broker in here today who speak to this better than I can. But it's a hard market for climate-related risk. And you're going to see your terms getting harder and harder unless and until climate change is dealt with. Under the current administration, I would not hold your breath. So, yeah, keep your eye on terms. The coverage is there if you're willing to pay for it. It's a cost-benefit analysis that these policyholders have to undertake. The other thing, obviously, whenever you get pushback from an insurance company that they want to pay less, they're telling you something's sublimited, or they're telling you there's a higher deductible that applies, always scrutinize that very carefully. Is it a named storm at all, right? think about, Sandy, think about Ida and Irma. At some point, these storms were downgraded from named storms to post-tropical cyclones. And there's a question that has come through the courts as to at what point is a named storm no longer a named storm, so that they can no longer charge you a named storm deductible, which will be higher.
Yeah, is that an issue at all in that New York case you were discussing, was it Sandy matter?
I don't remember anything. Do you know?
I do not know.
No, I don't recall that. It should have been. I don't know that was raised. I'm just not sure. But there are a couple of cases that I have looked at in New Jersey and California. We'll talk about them in a minute. But really what you have to do is look at your definition of named storm. That's going to be the critical piece of information here. And it often says whatever the National Weather Service declares as a hurricane, a tropical cyclone, or tropical depression, that will be your named storm. But as I mentioned, Sandy, Irma, Ida, these storms all lost their tropical characteristics. They were downgraded at some point, and they continued on to cause catastrophic damage in other locations after they were technically a hurricane. And if you remember with Sandy, the governors of all the affected states came out and they admonished the insurance industry and said, you better not, be trying to charge these higher named storm deductibles. They were mostly looking out for homeowners, obviously, but it applied equally to commercial properties. But nevertheless, some insurance companies continue to try to do this. There was a case in New Jersey where, a policyholder had an $800,000 loss and $1 million named storm deductible. So they would have completely wiped out coverage had this been applied. And this definition, if you read it here on the slide, it specifically said that the named tropical storm or hurricane ends when the National Weather Service officially declares the named tropical storm or hurricane permanently downgraded to a tropical depression. Despite this language, the insurance company still challenged it. They actually made a motion to dismiss the complaint, which is something that happens very early in the litigation. The court denied it, admonished the insurance company, and said, look, you're going to lose this. Basically, the writing was on the wall, they were going to lose this, and decided to favor the policyholder. There was a different result, though, in a California case that was upon New York law. That case defines named storm as a storm that has been declared by the National Weather Service to be a hurricane, typhoon, tropical cyclone, or tropical storm. It did not include that additional language that said, and by the way, it's no longer a named storm once it's been downgraded. So the insurance company fought this one, and it was a Sandy loss. And surprisingly, in my view, the court didn't rule in favor of the insurance company, but it also didn't rule in favor of the policyholder. It said that there was a question of fact. So that if the damage that occurred, which was happening to be a New York property, what it said was there was a fact issue as to, well, was it storm surge that created the damage, and was that storm surge the result of conditions that were created when Sandy was still a hurricane sitting out over the ocean, or was it the post-tropical cyclone when a landfall in New Jersey that caused the damage? So it ended up going to a jury, and not surprisingly, the jury found resoundingly in favor of the policyholder. It awarded attorney's fees. There is some legislation that is going on. There was something in New York, I apologize for the typo, there was a bill that was passed not in 2014, but in 2024, it was just last April, to try to make uniform the definition of named storm. This will only apply to homeowners policies, at least for now. It seems to have died on the vine. There's nothing going on with it since 2024, so I'm not optimistic, but you never know. And you see Mississippi enacted a similar law, so maybe there'll be some trend here where we'll start to see some legislation around these named storm deductibles. Switching topics now, we'll talk about flood supplements. Flood, Hope mentioned, this is another, obviously very significant climate-related risk. Again, another area where builders risk companies seek to limit their exposure, not surprisingly so. They'll either try to sublimit it in the policy or they'll try to exclude it altogether. And one thing to consider if you're faced with a flood sublimit is whether the flood sublimit applies only to your property damage loss, or if it also extends to the time element losses that we were talking about, right? Your delay in start, delay land opening coverages. And what you'll see in the policies is that flood supplements, they're often tied to physical loss or damage. And the argument is that that is different from your time element loss, right? Business interruption and time element losses, they're often stated separately from your flood supplements, so a separate limit for time element loss. There's a lot of variation in the policy. There's a lot of different provisions that the court will look at. I'll talk to you about a few. And it's sort of confusing interactions, but to try to sort of oversimplify it a bit, most courts that look at this say, I'm going to read the language of the policy. And if the policy does not explicitly say that your flood supplement applies to time element, I am not going to enforce that supplement. Conversely, of course, if the supplement is clear that it extends the time element, and by the way, many of them are, so you have to read the policy closely. If it is clear that it extends the time element, then they will enforce it and apply it to time element. But they're going to look at your flood supplement endorsement to see if it specifically references physical loss or damage. They'll look at your limits of liability section to see if there are separate limits stated for flood versus time element, like business interruption, whether you paid separate premiums for those coverages. Oftentimes you'll see in the declarations page that there's a separate premium paid for flood versus time element coverage. Excuse me. Importantly, they'll look to the definition of flood. Is there a tie in that definition to only physical loss or damage, right? And then they'll look at other sublimits and other limits in the policy and say, well, do those specifically identify that they apply to time element? Okay, well, they did it there, so we know they know how to do it when they mean it. If they intended the flood supplement to apply to time element, then they would have done the same with the flood supplement. So there's a lot of arguments to be made. Just, this is definitely something to key in on and take note of. Just a few cases up there, and this happened to be all the other Texas where the court ruled in favor of the policyholder and said that the flood supplement did not apply to the business interruption coverage as an issue. Another issue that made its way through the courts, this happened to me after Sandy as well, is whether storm surge is included in a flood supplement. Right? In the first case, this is an Amtrak case in the Southern District of New York. It had a $125 million supplement for the peril of flood, but flood was completely undefined in the policy, and it was storm surge that caused the loss, not flood. Notwithstanding that the policy failed to define what a flood was and whether or not it included storm surge, the court somehow found that the plain meaning of flood encompassed storm surge and it applied the supplement. Very different result just across the river in New Jersey, where the policy contained a higher named windstorm supplement and a lower flood supplement. And so, of course, the policyholder was saying that the storm surge loss at issue there was a named windstorm, and the insurance company was saying, no, it's a flood loss. And the flood definition included the term surge, but not storm surge. And the court actually found that the definition of named windstorm more specifically encompassed the wind-driven water that caused the damage at issue, because it was defined in the policy to include storm surge and flood associated with storms. That was the definition of named windstorm. So a good result for the policyholder there. And lastly, out of me anyway, I've included this slide just as sort of an example to show you the lengths to which an insurance company may go to try to limit its exposure with these flood-type supplements. So this was a hospital in Massachusetts where there was a severe convective storm that had catastrophic torrential rains, caused a lot of damage to this hospital. It was clear that the water that accumulated underground and affected the first floor and the basement was surface water within the definition of flood supplement there. But the insurance, and so the policyholder didn't fight that. They said, yeah, that's the first floor and the basement, that's all surface water from the accumulation of the torrential rains. And so that's limited under the flood supplement. The insurance company went a step further and said, well, hold on, we have a lot of accumulation of surface water on the roof as well. And that water came in and affected a lot of the lower levels as it trickled down into the building. And they said, that's surface water too, and that's sublimited also. I'm sure the policyholder said, well, not so fast. It's clear that surface water here, we're talking about ground level water accumulation. Water that accumulates on the surface of the earth, not the surface of my roof and my parapet, right? The insurance company said, no, it's waters that naturally accumulate on any surface, not just the surface of the earth. This went all the way to the Massachusetts Supreme Court, if you can believe it. And the court said, no, that is at least ambiguous and ruled in favor of the policyholder. So, but, lesson learned, you might be into some fights with the insurance companies on some of these issues, and persistence pays off. Now I will turn it over to Ethan to talk your ear off about smoke damage, heat coverage issues.
So we've been talking a bit about risk of loss under those risk policies and property policies, which first-party property policy is mentioned is similar to owner's risk in the basis of coverage. Those risks we talked about have been, flood-driven, wind-driven. We also have wildfires. Those seem like an obvious risk of what's going to cause a direct physical loss. But what about smoke and heat? Items like that or events like that you can't really easily perceive by the eye or see that there's actually direct physical damage arising out of that. So those risk policies typically are triggered by what is called direct physical loss or damage, or some variation of that phrase. We have a few variations on the slide, direct physical loss or direct physical damage. The question is, to what? To the insured property, typically. Sometimes you'll see some policies where it may include just the word to property, which you can argue is a little broader, and it may mean to property that's not specifically insured under the policy. Maybe it's other property down the street, for example. But typically, we're talking about direct physical loss or damage to insured property. Those terms are often not defined in these policies. So what does that mean then for direct physical loss or damage? Usually courts are the ones who have taken and determined that definition. And you see a lot of cases that were prior to the COVID-19 pandemic, but also especially concerning insurance coverage under property policies for COVID-19 related losses, have really examined what this means and have set forth the body of law. So in that context in particular, insurance companies argued, unfortunately overwhelmingly successfully, that the mere presence of COVID was not enough on the surface. That they would say, though, however, a structural alteration was necessary. This is where a lot of courts have at least agreed that a structural alteration may not be necessary to trigger coverage when there's a physical loss of damage or physical damage or risk of loss. So, there's some examples here from various case law over many, many years of when this coverage trigger has been met under first-party property policies. And let me take a second to note that, we're talking about all risk insurance. So under an all-risk policy, it's the policyholder's burden to show that coverage has been triggered in the first instance. So showing that there's risk of physical loss or damage is the basis there that triggers the coverage is what is necessary. Then it goes to the insurance company, and they bear the burden of showing, well, actually, there's an exclusion under the policy that can apply, so we're not going to cover you. So in any of these instances of extreme heat or of smoke infiltration on a construction project, in the first instance, it will be the policyholder's burden to show that that triggers the coverage. So, as an example, numerous courts have held over time that smoke can be a physical, can trigger coverage here. You also have asbestos fibers in the air that may trigger coverage. The smell of ammonia, cat urine, for example, under a New Hampshire case has been sufficient to trigger a property coverage. Off-tasting soda. There, there's not necessarily structural damage that's occurred in a property. What's been found there is that there's a sufficient perceived indication of change within the property such that it can be rendered unusable, at least for a certain amount of time. So New York recently, through its Court of Appeals, the High Court clarified in a COVID case something along those lines. Physical damage must be understood to require some sort of material alteration to the property. And it has to be perceptible even if it doesn't, even if it's not seen. So it has to require more than just mere loss of use of that property. It has to be an actual complete dispossession. So that had to be squared with prior case law that dealt with off-facing soda, for example, where there was no real harmful damage done to the soda, but it tasted bad, so no one would drink it. Well, that was a complete dispossession that court previously found of that soda for some time. Therefore, it triggered a property loss for the soda company. Meanwhile, you could look at California, which has a body of case law recently developed, starting with the first case here, which is a COVID case, then transitioning to some subsequent case law from federal and state courts out there that both dealt with smoke issues. Now, they're interesting because despite the California court reaching a similar directive in the Another Planet Entertainment case about COVID, similar to New York, that has to be a physical, demonstrable alteration of property that doesn't necessarily have to be structural. Two subsequent cases that dealt with smoke damage or smoke infiltration of property came to differing results. So the first case here, Bottega LLC, involved a series of restaurants. They were not actually touched by any wildfires, but they were very close to being touched by wildfires. There was such pervasive smoke infiltration that it was reported that months and even years after cleaning and after trying to repair the property, it still smelled like smoke in the property. It was almost a matter of quantity there. Versus, I'm going to butcher the way you pronounce it, the Meridian case was a homeowner's policy that also, there was no direct touching by fire. The fire was about a half a mile or less than half a mile away from the homeowner's house. There was smoke infiltration there. You could smell the smoke, but it was reported for less than 3 months. It was cleaned out. There was some minor repairs done associated with that. There, the court said that was not enough to trigger the coverage under that property policy because there was no evidence of direct physical loss of the property. So you can see how two courts, even applying the same state law, can come to differing results.
Ethan, I have a question.
Of course.
So in 2020, last year, 2024, during July, we had the Canadian wildfires.
Yes.
We had multiple sites within the city shut down because of air pollution concerns. How does that dovetail into this?
Well, that's perfect timing for the question. So, I want to talk about what's the effect of smoke infiltration on a construction project. Will it trigger the coverage here for builder's risk policy? Well, obviously, those were weird days, large size, and the smell like the barbecue inside the office building. That, clearly triggers an issue of worker safety concerns. But is a worker safety concern enough to trigger coverage under a builder's risk policy? An insurance company would likely argue that's not going to be some sort of alteration to the physical characteristics of the property itself. That's why a workers' compensation concern. However, my view is that it might depend on when the life of the project there is and the pervasiveness of the smoke. To say that there might be enough infiltration there that it should trigger, the coverage under a builder's risk insurance. If you have a steel structure only that's open air, then I think it's going to be probably more difficult to argue that that steel was itself affected by the wildfire smoke. Maybe different if you have issues of ash related to that steel. If you have a building that's near completion, that's full of, say, cabinetry in the kitchen, there's smoke infiltrating that, and it's pervading the smell that's such that you have to rip everything out and replace it, then I think there's a good argument that that's a direct physical alteration of the property that's perceptible from that smoke infiltration. But again, otherwise, if it's mere worker safety concerns, which I shouldn't say mere, that's not a mere issue at all, but if it's worker safety concerns, then I think that's more likely going to be a workers' compensation concern than it will ultimately be a builder's risk concern, unfortunately.
And that's a late, right? Because it can't work.
Right, so those are kind of those uninsured gaps perhaps in some ways that you might see in such instances in little ways. I want to note on another kind of gap here, which might mean if there are fires, we hear about wildfires in New Jersey across the river all the time, and smoke is excluded in New York City. But you may have instances of materials en route to the construction site in New York City that are held up because of a wildfire closing the highway in New Jersey. I mean, that's hypothetical. I don't know how frequently that actually has happened yet. There are kinds of insurance floaters, called installation floaters, that can ensure coverage, provide coverage for materials that are in transit essentially from the beginning point up until the time of installing the project. And so if there's a physical loss or damage trigger with respect to materials in transit, which could include would say that there's a wildfire that results in some sort of damage to those products, or maybe a delay there. There may be an argument that at least the cost of that product could be covered, and then sometimes that can include a soft cost endorsement that might allow for coverage to relate. Talking about smoke, I want to note though, I think the policyholder sometimes has some rare pollution exclusions in voters' risk policies because smoke may be within the definition of a pollutant or contaminant in the policy, which sometimes may fall, then the insurance company may say that falls under a pollution exclusion in the policy. So if a property is so affected by smoke, there shouldn't be any coverage the insurance company would say because it's excluded by the pollution exclusion. Well, typically those exclusions have been found to apply to traditional forms of pollution activity. They require some sort of dissemination or something like that. So I think the better way to think of that would be like an industrial release as opposed to the wildfires. All right. Going on, so talking about extreme heat, which is very much an issue. So, think of the same kind of body case law. Does extreme heat cause a physical alteration to the property or to other property like that might be on site? Because sometimes voters' risk extends to insured property beyond the actual structure. It may include materials being stored on the site to be installed in the use of that construction of the property. So, in order to mention the actual alteration of certain property, the warping of materials from the extreme heat events. So I think if we have warped materials, that's a very clear indication that extreme heat has caused some sort of physical alteration. Again, though, if it comes up issues of worker safety concerns, that may be a worker compensation issue. There may be gaps in coverage, which I just wanted to note. This is not something I think that we will see as coverage counsel very often in dealing with these kinds of claims, but there is a product called parametric insurance that's on the market that is essentially data-driven. It's set for an if-then scenario, where essentially a policyholder will say, I want to buy this kind of parametric insurance that says, if there is this criteria that say there is a hurricane on this date, whether or not it touches my property or in this time period, and it's category 4, then I get paid out this amount. So it's basically set up with a pre-agreed coverage trigger and a pre-agreed amount. So you're seeing some of these parametric insurance products being marketed overseas in certain areas with extreme heat. And you're starting to see it in a few U.S. markets, particularly in the Southwest, where it's been very high heat. Phoenix, for example, had multiple days of 100 degrees a few years ago that really interrupted construction. Of course, otherwise, this was a very dangerous time. So it's possible that could be a complement to gaps in voters' risk insurance, where if a parametric product is available. If it could be purchased to deal with heat days, we could say I want a trigger of 100 degrees Fahrenheit or a heat index of 100 degrees Fahrenheit, if we could apply to that. And I'm not a broker, so I don't know if that product is fully available to an extent. But I think it will become increasingly available, and if it is, I think that can be used as owners or developers as a gap builders risk for those heat days to account for at least some sort of payment if there is a delay.
All right, terrific. Thank you guys so much for joining. If there are any questions, we're happy to take them now, or we can discuss it over a cocktail.
Hi, my name is Karina, and it was a pleasure to attend today's event. It was very informative, and it addressed every single question I had about insurance.
Hi there, my name is Jessica Mora. I'm with Assured Partners Gallagher, and I'm an insurance broker that focuses on construction and real estate in New York City. My topic today was social engineering and deep fakes and AI in construction. And it's a really relevant topic to be discussing because a lot of construction companies just don't understand exactly what the risks are, and they still fail to have the right coverage in place. And so it was an opportunity to educate, which is something that I feel really passionate about. And if you're not sure about what or how that could potentially affect you, please take the time to watch some of the videos that Anderson Kill is posting on this website so that you can educate yourself and get the right coverages in place so that you're not a victim of fraud.
Hi, my name is Hope Kaufman. I'm an AVP with HNTB, focused on growth strategy in New York City. Today we were talking about builders risk and climate change. We felt that it was important to highlight just how uncertain this market is and the geography is in the New York City area, and how that really affects people who are looking to develop important properties and projects in the New York City area.
I'm Dennis Arteezy. I'm a shareholder with Anderson Kill in New York. Ethan and I, my partner, spoke about builder's risk insurance coverage and climate change risks associated with that and coverage for climate change risk. I highlighted things like named storm deductibles, downgraded storms, and flood sublimits, and a multitude of issues to be on the lookout when you are filing your builder's risk claims.
And I'm Ethan Middlebrooks, along with my partner Dennis Arteezy. I'm a shareholder at Anderson Kill, and I contributed to today's conversation talking about risk that one might not necessarily wonder if they're covered by builder's risk, such as smoke or heat issues. And if there's coverage to be had there or not, it's a difficult analysis that may require interpretation of state law.
Hi, I'm Miranda Fisher with Alliant Insurance Services. We just finished our panel on managing risk and contracts within the construction building space, I guess, in New York. I'd say the key takeaways from that would be to make sure that you have a great team of brokers and lawyers working in tandem to make sure that you're protected and you have more laughs instead of crying.
Hi, my name is Diana Gliedman. I am a shareholder at Anderson Kill. Today we had the pleasure of co-hosting the Hot Topics 25 conference with the Women Builders Council, where I had the pleasure of addressing the intersection of indemnity and insurance in construction contracts and emphasizing key takeaways that every construction contract or contractor needs to know to ensure that they are protected from risk.
Hi, I'm Melissa Villig. I'm an attorney with the law firm of Tannenbaum Halpern, where I'm the co-chair of the design and construction practice, and I'm here with...
My name is Jason Kozak. I am a shareholder at Anderson Kill, and we spoke on today's panel called Construction Contracts and Risk Transfer. We talked about different ways to manage your contracts and manage risk. The thing that I would say that took away from our presentation is to always, recheck your insurance policies and your contracts every year. Make sure they're up to date and don't rely on standard form templates, because then you're gonna miss out and suffer a lot of damages in the future.
And I think that my key takeaway is to make sure you talk to your lawyer about your contracts and the risks, and your broker about your coverage to make sure you have what you need.